Court Without Counsel, How to Win Without a Lawyer in the AI Age by Laing Z. Chapter 1. The Old Guides and the New Reality. Section 1. The Books That Taught Us How to Survive. Long before self-represented litigant became a headline term or a constitutional talking point, there were a handful of books that quietly gave ordinary people permission to step into a courtroom without a lawyer. Titles like Representing Yourself in Court, Journey to Justice, The Self-Help Guide to Canadian Law, and a scattering of local clinic manuals served as lifelines for people who had nowhere else to turn. They were often written by well-meaning lawyers, legal aid staff, or retired judges who wanted to demystify the system. And in many ways, they succeeded. They walked readers step by step through procedure: how to file a claim, how to serve documents, how to behave before a judge. They translated Latin into English, explained the difference between an affidavit and a notice of motion, and included templates that, for the first time, allowed ordinary people to participate in legal processes without hiring counsel. Those early guides mattered. They were, for many, the first glimpse of a radical idea: that justice wasn't just for lawyers. They made people believe, often for the first time, that they had the right to speak in their own defense, to fight for their own children, homes, or reputations, even if they couldn't afford to pay someone else to do it for them. I have enormous respect for the authors of those books. They gave thousands of Canadians the courage to walk into court alone, and that courage changed lives. It still does. The world they were written for. But those guides were written for a different era, a legal world that no longer exists. When Representing Yourself in Court was first published, legal aid, while never generous, was still widely available. Filing fees were manageable. Court schedules were busy, but not yet drowning under the weight of today's caseloads. Judges had more time to hear unpolished arguments. Most importantly, the adversaries SRLs faced were, more often than not, other individuals. The era of corporate lawyers filing 400-page motions to crush a tenant, or government lawyers fighting procedural wars over technicalities, was still in its infancy. The terrain was difficult, but navigable with patience and common sense. The old guides reflected that world. They assumed that if you followed the rules, stayed polite, and presented your evidence clearly, you'd be treated fairly. They assumed the playing field, while uneven, wasn't actively hostile. And in their time, those were fair assumptions. Why they still matter, and why they're no longer enough. We must give credit where it's due. Those books democratized basic legal knowledge. They proved that ordinary people could participate in their own cases. They gave language to the powerless. And they built a foundation on which this book, and every SRL who has come since, now stands. But stepping stones are not destinations. The legal battlefield has changed. Today's courtrooms are busier, harsher, and more complex. Legal aid has evaporated for most civil and family matters. Cost awards can bankrupt people. Procedure has become a weapon rather than a guideline. Judges are less patient, opposing counsel more ruthless. And the sheer volume of information, evidence, precedents, procedural minutiae has exploded beyond anything an individual could realistically manage 20 years ago. The old maps still show the roads, but the terrain has changed. And if you follow them blindly now, you won't just get lost, you'll get crushed. A new war, a new playbook. What those early guides did was give us access to the field. What this one intends to do is teach you how to win on it, because the fight has evolved, the rules have shifted, and the opponents, well-funded, AI-armed, procedurally sophisticated, are no longer playing the same game. They're not just arguing law. They're exploiting bias. They're weaponizing deadlines. They're using procedural ambushes and data-driven strategies to exhaust and overwhelm you before you ever set foot in front of a judge. And if all you have is a 1990s-era handbook telling you how to stay polite and follow the steps, you're walking into a drone war with a spear. That's why this book exists. Not to replace those early guides, but to go far beyond them. To arm you with the strategies, the tools, and the mindset required for the courtroom as it actually is today. Because this isn't about surviving anymore, it's about winning. The first generation of SRL guides broke the monopoly on legal knowledge and gave ordinary people a fighting chance. But the world they were written for is gone. The justice system has grown more complex, more adversarial, and more hostile. And if you don't adapt, you will lose before the battle begins. This book is not about building a raft to stay afloat. It's about building a warship, one designed for the rough waters of the courtroom as it exists now. Section 2, where the old guides fall short. The early self-representation manuals were written with good intentions, and they were good books for their time. They explained the basic anatomy of a case, translated legal jargon into plain English, and told you how to stand up straight and speak clearly in court. But here's the brutal truth. They were written for a legal world that no longer exists. They were designed for a system that assumed good faith, that moved at a human pace, and that still believed the courtroom was a neutral arena where arguments rose or fell on their merit. That's not the world you're walking into. The justice system has evolved, or depending on how cynical you are, devolved. What used to be obstacles are now weapons. What used to be inconveniences are now deal breakers. And the assumptions that underpinned those older guides, that fairness was the baseline, that procedure was a formality, that losing was survivable, are dangerously outdated. It's time to look clearly at where those guides fall short, because unless you see the battlefield for what it truly is, you won't even know which direction to face. 1. Systemic bias is the unspoken enemy. If the old guides have a single fatal flaw, it's this. They assume the system is neutral. They tell you that if you follow the rules, speak politely, and present your evidence clearly, you'll get a fair hearing. But anyone who's spent more than a week inside a courtroom knows that's a fairy tale. Judges, clerks, and opposing counsel, whether they admit it or not, carry biases about self-represented litigants. Some are unconscious, others are not. They see SRLs as nuisances, time wasters, or amateurs who don't understand the rules and therefore don't deserve the court's time. They assume your arguments are misguided. They assume your filings are flawed, and they often treat you accordingly. The same legal argument, word for word, will land differently depending on who is speaking it. A lawyer's submission is well argued. A self-represented litigant's is emotional or unfocused. A lawyer raising a procedural objection is zealous. An SRL doing the same thing is vexatious. The scale doesn't start at 0. You start 3 points behind. I once watched a tenant present a meticulously prepared case against a landlord who had ignored safety violations for years. She had photos, inspection reports, and witness statements. Everything she needed to win. The judge barely looked at them. Instead, he chastised her for filing too many documents and dismissed key arguments as speculative lay opinion. Had a lawyer said the same words, the tone would have been persuasive advocacy. That's not a one-off story. That's the daily reality of Canadian courtrooms. And because the old guides ignore this, they fail to teach you the most important skill of all: how to neutralize bias. They don't teach you how to frame arguments so judges take them seriously. They don't show you how to present yourself in a way that signals competence before you even speak. They don't prepare you for the fact that the fight isn't just about what you say. It's about who the system thinks you are. 2. Procedural traps are now a primary weapon. The old books treat procedure like a checklist. File this, serve that. Don't miss this deadline. But in modern litigation, procedure isn't a background task. It's the battlefield itself. And it's where most SRLs lose, before their case ever gets heard. Opposing counsel knows this. They know that if they can bury you in procedural complexity, they can win without ever having to argue the facts. They'll exploit every technicality, every formatting error, every missed deadline. They'll file procedural motions not to win them, but to drain your time, money, and energy. They'll weaponize disclosure requests and discovery demands until you drown in paperwork. Classic SRL manuals warn you not to miss deadlines. They do not teach you how to use deadlines to create pressure, to gain leverage, to force disclosure. They don't show you how to turn procedural traps on your opponent or how to anticipate the ambushes that will almost certainly be deployed against you. Today, knowing the rules isn't enough. You have to wield them like weapons. Because if you don't, someone else will, against you. 3. Cost barriers have grown into constitutional walls. When those older guides were written, losing a motion was disappointing. Losing a trial was expensive. But for most people, neither was catastrophic. That's no longer true. Legal aid eligibility has collapsed. Court filing fees have risen. And cost awards, the court's way of making the losing party pay the winner's legal bills, have become ruinous. It's now common for SRLs to walk out of court not just having lost their case, but owing tens of thousands of dollars to the other side. The old guides don't prepare you for this reality. They assume that litigation is a matter of principle, but today, it's also a matter of survival. You must think like an investor. What's the return on this motion? What's the risk of a cost award if I lose? Should I strategically withdraw now to fight another day? Should I negotiate a settlement instead of gambling on a verdict? That kind of strategic thinking is nowhere in the older books, and without it, you're not playing the same game as your opponent. They're playing chess. You're playing checkers. 4. Technology has completely changed the game, and they missed it. The legal world those guides were written for was made of paper, not pixels. You found case law in libraries. You served documents by courier. You lugged binders into court. Judges scribbled notes by hand. It was slow, physical, and linear. None of that is true anymore. E-filing portals have replaced paper. Virtual hearings have replaced courtrooms. AI-powered legal research tools can summarize thousands of cases in minutes. Opposing counsel now uses software to comb through disclosure, flag inconsistencies, and build timelines. And some judges, yes, already, are using AI to draft parts of their decisions. The old manuals were written for a spear fight. Today, the people you're up against are flying drones. They have automated systems for everything: research, drafting, scheduling, even predicting judicial behavior. And if you're not aware of this reality, you're fighting a battle that's already over before you start. The irony? These same technologies can now be used by you, but none of the classic books even mention them because they were written before the revolution began. The real lesson. This isn't about tearing down the books that came before. They were essential, but they were also products of their time, and their time has passed. Those guides were written for a justice system that no longer exists. The battlefield has shifted. Opposing counsel now uses procedure as a weapon. Judges are less patient. Costs are more punitive. And the tools available to you are infinitely more powerful. The old manuals can still teach you how to build a spear, but your opponent is carrying a drone. The new reality demands a new kind of guide, one that assumes bias, anticipates traps, accounts for cost risk, and embraces technology as an equalizer. Because without that, you're not just unprepared, you're already defeated. Section takeaway. The greatest weakness of the old SRL guides isn't what they say, it's what they don't. They don't prepare you for the systemic bias that shapes outcomes before a word is spoken. They don't teach you how to weaponize procedure or navigate financial risk. And they don't recognize the technological arms race transforming the courtroom. This book does. Because knowing what to do is no longer enough. You need to understand how the fight is fought now and how to win it. Section 3. The AI Advantage, the Rise of the SRL 2.0. For decades, the legal system thrived on one unspoken truth. Access to justice was gated by three currencies: education, time, and money. If you didn't have all three, you were locked out of the game. A law degree cost 6 figures. Researching cases took weeks. Drafting a motion could eat up an entire paycheck. And the very idea of arguing against a seasoned litigator without those resources seemed absurd. That world is dying. A quiet revolution is underway, and it's happening faster than the legal profession wants to admit. Artificial intelligence, once the stuff of science fiction, has begun dismantling those gates. It is taking tasks that once required years of training, thousands of dollars, and armies of junior lawyers, and placing them within reach of anyone with an internet connection and a laptop. For the self-represented litigant, this isn't just an upgrade. It's an equalizer. It is the single greatest strategic shift in access to justice in a century. 1. What's changed and why it matters. A decade ago, preparing for a serious civil or family case without a lawyer meant living in the library, poring over dusty law reports, trying to decipher Latin phrases and procedural rules written for insiders. Even the most determined SRL would be hopelessly outgunned. A single round of legal research might take a junior associate 40 billable hours and cost you $10,000 if you tried to outsource it. Now, a well-prompted AI can summarize those same 40 hours of research in under 5 minutes. And it's not just speed. AI tools can synthesize, analyze, and contextualize. They can explain how a case has been interpreted across jurisdictions. They can break down a 100-page judgment into a 5-point summary. They can map procedural timelines, cross-reference statutes, and even forecast likely judicial outcomes based on precedent. This means that the average self-represented litigant, with the right tools and training, can now walk into court with a level of preparation that would have cost $20,000 in billable hours a decade ago. And they can do it for free, or for the price of a monthly software subscription. Let that sink in. The knowledge gap that once made SRLs easy prey is closing, fast. And that terrifies the system, because the minute ordinary people have the same access to research, drafting, and strategy as the legal profession, the monopoly on justice begins to crack. 2. Practical use cases. AI as your co-counsel. The potential applications of AI for SRLs are vast, but let's break them down into 5 core battlefronts, the places where AI can transform you from a legal novice into a formidable opponent. A. Research, a 24/7 junior associate. Traditional legal research is slow, expensive, and exhausting. AI turns it into something anyone can do. With a carefully crafted prompt, you can ask, summarize the 5 leading cases on fiduciary duty in Canadian family law since 2010. Explain how the Supreme Court has interpreted Section 7 of the Charter in access to justice cases. Compare Ontario and BC jurisprudence on cost awards against SRLs. In seconds, you'll have a synthesized overview, not just a pile of citations, but a digestible roadmap you can actually use. The trick is learning how to ask well, and this book will show you how. B. Drafting, from amateur to professional. One of the hardest parts of self-representation is producing documents that look and sound credible. Judges are trained to expect a certain format, tone, and logic. AI can help you meet, or even exceed, that standard. You can feed it a rough draft of your affidavit and ask it to rewrite it for clarity and concision. Flag any sections that might be considered irrelevant or inflammatory. Suggest citations to strengthen your legal position. The result? A document that reads like it was drafted by someone with a law degree, even if it wasn't. C. Strategy. Playing chess, not checkers. Lawyers spend years learning how to anticipate counter-arguments and shape legal narratives. AI can now do much of that work for you. Feed it your opponent's filings and ask, what are the strongest counter-arguments they're likely to raise? How might a judge critique this argument? What case law could undermine their position? This isn't about letting AI think for you. It's about using it as a sparring partner, a strategist that never sleeps and has read every case ever decided. D. Evidence. Organize, tag, dominate. Disclosure in modern litigation can be a nightmare. Hundreds of pages, thousands of emails, dozens of exhibits. Most SRLs are buried alive before they even get to trial. AI can change that. With document review tools, you can tag documents by relevance or issue, auto-summarize witness statements, create timelines that map evidence chronologically. What used to take a paralegal team a week now takes you an afternoon. E. Case simulation. Meet your mock judge. Perhaps the most powerful and underutilized application of AI is simulation. You can run your entire case, argument by argument, through a mock trial. You can ask AI to play the role of opposing counsel, cross-examining you, or to act as a judge and render a hypothetical ruling. The point isn't that the simulation will be correct, it's that it will expose blind spots, weak arguments, and strategic opportunities before you step into the real arena. 3. The limitations and ethical boundaries. Now, before we go any further, a word of reality. AI is not a lawyer. It cannot give legal advice. It can make mistakes, sometimes spectacular ones. It can hallucinate false cases, misunderstand statutes, or overlook key procedural nuances. Think of AI not as your advocate, but as your co-counsel. It's the researcher who works 24/7, the strategist who never gets tired, the assistant who drafts tirelessly. But it still needs your judgment to guide it. The most effective SRLs will learn where AI ends and where they begin. They will double-check citations. They will verify case law. They will use AI to augment their arguments, not outsource their thinking. And perhaps most importantly, they will know the ethical boundaries. Misrepresenting AI-generated material as legal advice is dangerous. Submitting fabricated citations can get you sanctioned. Courts are increasingly alert to AI fakery, and credibility, once lost, is hard to regain. Used wisely, however, these tools are game-changing. They don't replace skill, they amplify it. They don't guarantee victory, they make victory possible. Caveat box. AI is your co-counsel, not your counsel. Use it to empower your decisions, never to replace them. Double-check everything. Verify every citation. Your judgment is the final word. The SRL 2.0 mindset. Here's the most important shift AI introduces. It moves you from a position of defense to one of offense. The first generation of SRL guides taught you how to survive, how to follow the rules, file the right forms, and avoid embarrassing yourself. AI makes survival the starting line, not the finish. Now you can strategize, simulate, and strike, just like your opponent. You can walk into court not hoping to be understood, but determined to win. And when thousands of SRLs begin showing up with the polish, preparation, and precision once reserved for those with six-figure retainers, the system itself will have to adapt. Judges will have to stop dismissing self-represented litigants as amateurs. Opposing counsel will have to stop underestimating them. The courtroom will start to look less like a private club and more like a public forum again. Section Takeaway. The rise of AI has shattered the old assumptions about who can and cannot fight effectively in court. It gives self-represented litigants access to the kind of legal research, drafting, strategy, and simulation that once required an expensive law degree and a corporate firm behind them. But tools are only as powerful as the hands that wield them. Used wisely, AI is not a gimmick. It's a weapon. And in the chapters ahead, You'll learn how to sharpen it to a razor's edge. Section 4. The mission of this book. There's no polite way to say this. Most books about representing yourself in court were written to help you endure the legal system, not to defeat it. They were built to get you through the storm in a leaky raft, not to arm you with a warship. This book is not an update to those manuals. It's a revolt against them. It's the first self-representation guide written with a single, unapologetic mission: to teach ordinary people how to win. 1. From survival to strategy. The legal establishment prefers self-represented litigants to stay in a particular lane. They want you quiet. They want you respectful. They want you to follow the rules and still lose. Most SRL guides were written in that spirit. They teach you how to avoid embarrassing yourself, how to format documents correctly, how to speak politely before the bench. Those are good things, but they're not enough. Here's the hard truth. If you walk into a courtroom believing the system will reward you simply for being polite and prepared, you've already lost. The system doesn't reward politeness. It rewards power. The power to marshal facts, wield procedure, control narrative, and anticipate attacks before they're launched. That's what this book is here to teach you. It's not about being tolerated. It's about being feared. 2. Bias is real, and we face it head-on. The first rule of courtroom warfare is to stop pretending the battlefield is fair. Judges are human. Clerks are human. Opposing counsel is not just your adversary. They are often the system itself, fluent in its language and trained to exploit your ignorance. Where other books treat this bias as an unfortunate side effect, this one calls it what it is: a strategic reality that must be factored into your every move. It's why we'll spend time learning how judges actually think, not how they're supposed to. It's why we'll study how opposing lawyers exploit procedural loopholes to bury SRLs in paperwork. And it's why we'll build counter strategies not based on theory, but on how things really work. Because if you don't account for bias, bias will account for you. 3. Procedure, your greatest weapon. Ask any seasoned litigator and they'll tell you, most cases are won or lost before the trial ever begins. And they're often decided not by evidence or argument, but by procedure. The technical, boring, seemingly trivial rules that determine whether your case even gets heard. This book will teach you how to make those rules work for you instead of against you. You'll learn how to use procedural deadlines to corner your opponent, how to turn disclosure requests into discovery weapons, how to transform motions from defensive chores into offensive strikes. The old guides told you to respect the rules. This book will show you how to wield them. 4. Litigation as strategy, not survival. The biggest mistake SRLs make is thinking the courtroom is a place to tell their story. It isn't. It's a place to win a contest of narratives, waged within a rigid set of rules. That means every move must be strategic. Every sentence must have a purpose. Every piece of evidence must be part of a larger plan. You will learn how to approach your case like a campaign, one with phases, objectives, feints, and counterattacks. You'll learn how to manage risk, when to advance and when to retreat, and how to build leverage long before you ever stand before a judge. In short, you'll stop acting like a desperate litigant and start thinking like a field commander. 5. Tools that level the field. For decades, the law's greatest advantage was its monopoly on expertise. Lawyers had the research tools. They had the drafting software. They had the experience to anticipate outcomes. You had a stack of photocopies and a highlighter. That era is over. This book will show you how to use the same technological firepower law firms rely on, and often do so better. You'll learn how to turn AI into your junior counsel, your research department, your argument coach, and your document manager. You'll see how predictive analytics can warn you of likely outcomes before you file. And you'll discover how automation can free you from the drudgery of forms and filings so you can focus on what matters: winning the case. No other SRL guide has ever dared to weaponize technology this way. But no SRL guide was written for this moment in history, when, for the first time, the balance of power is starting to tilt. 6. The real mission, and why it matters. Let's be clear about what this book is not. It is not a how-to pamphlet on representing yourself politely. It is not a collection of legal trivia. It is not a feel-good story about access to justice. It is a strategic manual for ordinary people to fight back against a system that has long assumed they never could. It will show you how to litigate like a strategist, argue like a lawyer, think like a judge, and fight like you belong in the room, because you do. The ultimate goal is bigger than winning your case. It's about changing the culture of the courtroom itself. When self-represented litigants stop showing up as victims and start arriving as equals, the system must evolve. Judges will have to adjust their expectations. Lawyers will have to raise their game. And the idea that justice is a product you buy will begin to collapse. 7. From rafts to warships. The best way to think about this book is as a new kind of map. Previous guides were written to help you survive the waves, to build a raft and hope it holds. This one is about building a ship, something strong, strategic, and capable of sailing through the storm and into the fight itself. It's not a manual for staying afloat. It's a blueprint for taking the helm. Key takeaway: this is not just another self-help book for litigants. It's a blueprint for power over procedure, over bias, over fear, and over the narrative that says people like you can't win. By the end, you won't just understand the legal system, you'll know how to bend it to your will. Next chapter, preview. If this chapter explained why the old maps no longer work, the next one will reveal the terrain as it truly is: the courthouse ecosystem, its hidden hierarchies, and the subtle currents of power that shape every decision before a single word is spoken. Understanding that landscape is the first step toward mastering it.